Gujarat High Court Advocates Association, I welcome you all to the present half-day seminar that has been arranged. Once again, in order to cater to the needs of the members of the bar, we have brought before you three eminent speakers and the lawyers who are also the members of our association, who would be delivering their keynotes on the crucial topics which have been selected for the present discussion. Friends, it is not possible to hold such type of educational seminars unless and until there is an active participation from the office bearers. They have indeed shown a keen interest that members should be given maximum benefits of their experience so that it would be made very much conducive and smooth for the day-to-day practice before the High Court. I welcome our Vice President, Mr. Asim Pandya, to come on the dais, who is also the speaker of today's seminar. I would also welcome on the dais Mr. Sudhanshu Patel, the General Secretary of our association. I also welcome Mr. Nirav Trivedi, the Joint Secretary of our association, to come on the dais. Of course, I also extend my thanks and warm welcome to all other committee members and office bearers, without whose participation and cooperation, these seminars are not possible to be arranged. I once again welcome you all, not only on my behalf, not only on behalf of association, but on behalf of all our office bearers. And I also welcome you on behalf of our President, Mr. Yatin Oza, who is not in a position to remain present just now, but he has expressed his willingness to join us in the midst of the seminar as soon as this professional assignment is over. Now friends, beginning with the first topic, the myths and misconceptions about the REITs. A very controversial topic. And in fact, I said that since last 5 years, this has already gained a superior attention and has created a lot of controversies. I reminded of my days of studies in the law when we used to study REITs. And it was not so tough for us to compartmentalize the 5 categories of REITs under Article 226. However, the present development which has taken place in the judicial scenario is such that there are many complications in understanding the REITs have itself arisen. Say, the Supreme Court said that the REIT of certiorari against the civil court would not be maintainable under Article 226 but 227. So such type of judgments have come that have created more anxiety on the members of the bar, that then under which provisions of the Constitution the proper REIT could be filed. In order to highlight these issues and in order to eradicate certain illusions and doubts from our minds, we have with us an eminent speaker and the member of our association, Mr. Asim Pandya. He is, apart from being a great advocate, he is a well-known author who has written the book on the very subject, the law of writs and constitutional remedies. He is also an author on the Contempt of Courts Act. He is also an author on law of bail, the book that has been published. And he is also an author on the book relating to excise duty, excise law. Besides the fact that he has written various books, he is a regular contributor of articles in various law journals. So whenever some controversial issue arises, he would immediately pen down the article and would contribute to the law journal. And with a view to contribute this law journal reports, his articles, his basic objective is to see that let his views go right amongst the lawyers who are practicing even in districts and taluka level. Sir, we are indeed very happy to note that you have consented to come. You have devoted the time for the members of our association. So now I would request Mr. Asim Pandya to deliver a valuable and significant note on the subject, myths and misconception of law of REITs. Please welcome. Yes, a very gentle request which I forget to mention. Don't be under the judicial interference with the help of mobile. He is author of contempt of courts. Please, switch off your mobile. Please.
Good morning to all my dear colleagues at the bar. I see familiar faces. I see some very senior advocate. And I request Mr. Kaushik Pujara to come here so that it would inspire us. It is not that junior members don't inspire, but when senior is present, it indeed gives a great pleasure to the speaker that even senior member evinces their interest in the legal seminar.
Sir, it is a humble request. It is a request, sir. Pujara Sahib, please come on. Please, please. Please, sir.
Anyway, good morning to all of you. Our profession demands constant learning. And in our endeavor to say that our members constantly learn new things and keep themselves abreast with the latest development, we regularly hold these kind of seminars. And I am really glad that you have come in this large number to attend this seminar and inspire the speakers to deliver their lectures. Friends, the subject which I have chosen, myths and misconceptions about Article 226 and 227. During 27 years of my practice, I have seen that there are large number of misconceptions and myths are prevalent not only among the lawyers, but also the judges. Not judges of the High Court, but it reaches up to the Supreme Court also, because ultimately everyone is a human being. And to err is a human. So we simply follow the Supreme Court's decision because Supreme Court is the final court and it's a Supreme Court. But that does not necessarily mean that the judgments laid down by the Honorable Supreme Court always are correct. That is not the correct proposition. So since I have come across number of this kind of misconception, I thought that why should we not discuss these misconception and myths which is prevalent with all our members so that it would impart some clarity in this jurisdiction. Now I will start with one question, that how many of you have read Article 226 in last 1 year or during their entire practice? If somebody has read this article thoroughly, please raise your hand. That's good, okay. So I see very few hands. And if you ask the same question to the judges, they would also perhaps say that they regularly do justice in a petition filed under Article 226. But there is rarely any occasion where this article is actually read in the courtroom. My personal experience is also such Perhaps in this career of about more than 25 years, I had no occasion, except I may say one or two occasions, where I may have read this article in the courtroom. Because everyone thinks that, yes, this is a routine thing and we know Article 226. There is no need to read it. And same is the case that every petition is under Article 226, so we need not read it at all. Now, not reading this article again and again, first of all, one has to read it once. Then it is required to be read it again and again. Only if you read it again and again, then only you will have some clarity on this article. So I would first request that whenever you get an opportunity, because there are very niceties and finer nuances under Article 226, which I would try to highlight in this seminar. Friends, if you see Article 226 in isolation, divorced from the historical background, I am sure that it will not lead you to the clarity. If you really want complete clarity, you must see the historical background. And in a very short time, I will give some historical background because it has a direct relevance with the Article 226, which is in present form. It is not a sudden enactment. There is some historical aspects which are required to be highlighted before this audience. Now, first myth, I will start with the first myth, which has some relevance with the historical aspect. Most of the people think that this is a continuation of the old jurisdiction. We are quite aware of the fact that before the Constitution was framed, the high courts were already there. They used to issue these traditional writs, namely habeas corpus, mandamus, certiorari, quo warranto, prohibition. So this gives an impression that since earlier these writs were being issued by the high courts established under the letters patent prior to the Constitution, Article 226 has simply continued that jurisdiction only. So that is a myth and misconception. Maybe I'm not saying that all of you are suffering from that myth or misconception, but the tendency to describe this jurisdiction as writ jurisdiction has created this trouble. In my respectful submission, this description is a misnomer. It's a very wide jurisdiction, which of course I will take you to the actual text of the article little later on. But on the aspect of this, whether it's a continuation of the past jurisdiction or it is an entirely a new jurisdiction. So I will start with the answer first. This is absolutely a new jurisdiction. It is not a continuation of old traditional writ jurisdiction. The high courts were for the first time established by Indian High Courts Act 1861. The letters patent issued under the Indian High Courts Act 1861, you might be thinking that they must have conferred this writ jurisdiction to High Court. That is incorrect. In fact, for the first time, this writ jurisdiction of issuing traditional prerogative writs was conferred on three presidency Supreme Courts, because by Regulating Act 1773. That was the first enactment which gave power to establish Supreme Court in India by British government. So that is the first act which you must keep in mind, that Regulating Act 1773. Under this act, for the first time in 3 presidency towns, namely Forts William at West Bengal, that is Calcutta, Bombay and Madras, by a different charter of first charter was 1774, whereby Calcutta High Court, Supreme Court was erected, and it was followed by charter of 800, whereby Madras Supreme Court was established, and later on Bombay Supreme Court was established in 1823. Now by this charter, for the first time, the judiciary, that is Supreme Court, at judicature at these 3 presidency towns, were conferred with the prerogative writ powers. Clause 4 and 24 of the Charter of 1774 equated the jurisdiction of this Supreme Court with the jurisdiction of King's Bench in England. So that is how, for the first time, judiciary in India derived its jurisdiction to issue prerogative writs. So this is the beginning point of our history, which has ultimately culminated in the Article 226 in the present form. But this is the basis through which this jurisdiction is derived. Now, in 1856, after that armed rebellion, British government took over the control from East India Company. One interesting aspect, that why these towns are described as presidency town. Because the president of East India Company used to stay in these 3 presidency towns. So since the president was staying in these presidency towns, they have been described as presidency towns. Now when this armed rebellion took